office from one state to another under Companies Act 2013. So shifting of registered office from one state to another is a strategic business decision. It is governed by Section 12 and Section 13 of Companies Act 2013, read with Rule 30 of Companies Incorporation Rules 2014. So why these changes? So these changes often allows companies to access any new business opportunities, benefit from favorable state-specific policies, expand their market presence, or ease operational management. So, however, due to its legal complexity, prior planning, shareholders' approval, and central government sanction via regional director, these are all mandatory. Here, central government is RD approval. So, what is the legal framework for shifting of registered office from one state to another state? Here, Section 13 of Companies Act 2013, alteration of memorandum. Because under Section 13, subsection 1, special resolution is required to alter MOA, Memorandum of Association. Under Section 13, subsection 4, if the registered office is shifted from one state to another, prior approval of the central government, that is through RD, regional director, it is a mandatory under Section 13. Under Section 13, subsection 5, application must be disposed of within 60 days. It's the time bound. The objective is to ensure that creditors and stakeholders' interests are protected and sufficient provision or security is made to discharge any liabilities. So that is the reason it has to be disposed within the timelines. We'll talk about Rule 30 of Companies Incorporation Rules 2014. So the company must file INC 23 with the RD. Along with the attachments are altered MOA, board resolution, shareholders resolution. We have already discussed special resolution. And list of the creditors and debenture holders not older than 1 month. And directors a declaration, no objection from stakeholders. Copy of application sent to ROC, Chief Secretary of the State, SEBI in case of listed company. And also the company must advertise the shifting of proposal in one in English and one vernacular newspaper, prescribed format, Form INC 26. So advertisement of shifting proposal is in Form INC 26 in one English newspaper and one vernacular newspaper. And serve copies of advertisement to all stakeholders, including ROC, RD, SEBI, and creditors. Now we discuss on procedure, step-by-step process for shifting of registered office. First, convene the board meeting to propose shifting of registered office and MOA amendment. Then prepare the documents for approving of EGM and special resolution drafts, keep ready, and issue EGM notice to shareholders. So for this T+7, so board meeting date we can call it as a T. So it will take T+7 for sending notice to shareholders. Then anyway, we will give 21 days notice. Post for +2, so 23 days notice. So EGM meeting for passing a special resolution T+32. And we need to file MGT 14 with ROC by attaching special resolution and altered MOA. MGT 14 within 30 days. So maximum T+62. Prepare the latest list of creditors and debenture holders not older than 1 month. And advertisement notice in newspaper INC 26 form. Not more than 30 days before filing of INC 23. Not more than 30 days before filing of INC 23. And some newspaper and copy to stakeholders. Advertisement copy to stakeholders. So serving of this newspaper advertisement copy immediately after publication, serving to stakeholders, no objection from creditors, obtaining no objection from creditors before application filing, and serve full application with the annexures to ROC, RD, Chief Secretary, SEBI if applicable, and file application with ROC, the form GNL2, and file main application with the RD, that is INC 23. On RD approval, file order with ROC, that is INC 28 within 30 days. File e-form INC 22 for new office address. This is post approval. So documents are required is certified copy of MOA, board resolution, notice of EGM, certified special resolution with the explanatory statement, and list of creditors and debenture holders, if any, not older than 30 days, and affidavits duly notarized. Affidavit verifying petition, affidavit verifying list of creditors, confirming non-retrenchment, and confirming publication, confirming service to authorities, and verifying employees list, and memorandum of appearance if advocate, wakalatnama, and latest audited financials with directors and auditors reports, and board resolution authorizing filing with RD and appearance. So these are all the copies required. Then important to note is if no objections are raised within the timeline, then regional director may pass approval without hearing. If no objections are raised within timelines, so all the documents are in place, then RD may pass without any hearing also. If form is in line with all the copies within timelines, and if objections are raised, then RD will conduct a hearing, seek consensus, and only then issue the order. Ensure timely and documented communication with all regulatory authorities and stakeholders. Compliance is critical to avoid rejection or delay in shifting. So now the conclusion is shifting of registered office from one state to another is not just a procedural change. It impacts the taxation matters and jurisdictional matters, ROC oversight, regulatory compliance, and stakeholder communication. So it must be executed with the legal diligence, timely findings, and transparent disclosures. Now the references are Companies Act 2013, Section 12, Section 13, and Companies Incorporation Rules 2014, Rule 30. And the forms which are required to file is INC 23, INC 22, INC 26, INC 28, MGT 14, and GNLT. And we have 2 channels. Please do subscribe RR Corporates and RR Legal Talks for all latest updates. Hit the bell icon so that you will not miss any of the latest article. Thank you.